Absolutely. We came out because I said I would come out to call the 130 case. There were two people in my Zoom waiting room, Mr. Green and my clerk.
If I can have an opportunity to talk to him like this, he's looking at this, he should probably.
Do you want to go? Do you have a? You have a device? Well, I'll put you into a breakout room if you have a device.
I don't know if I can use my phone for this.
Or there's a computer downstairs in the probation waiting room that is Zoom available. You can log onto my courtroom and I'll put you in a breakout room with your client. If you want to do that.
Well, I think it might resolve
Okay.
some issues here.
If you want to, you can do that.
And Brandy sent the exam.
Brandy's case is moved.
There's a 1:30 and a 2 o'clock. Okay.
The 1:30, I think, is a different case.
Mr. Bickert is the 1:30.
So
Mr.
sorry,
Bickert is the 1:30 and Ms. Robinson's the 2 o'clock. Are you gonna go downstairs?
Yes.
Okay. Mr. Green?
Can you fake freezing?
No, I see that his signal is in the red. There at the bottom left.
If you go downstairs and log on to my Zoom, as soon as I see you, I'll bring you in and I'll put you right into a breakout room with him.
Hold on, I think we're waiting for Mr. Becker on the 1:30 then.
I think that's what's going on. Thank you. I know.
yes.
I'll be next door.
ma'am.
Thank you.
I'm so sorry about this. I didn't call. I just,
Mr. Green?
yes, ma'am.
Your attorney is going to log onto the computer. I'm going to put you into a breakout room with him.
I'm here,
It
ma'am.
might help your signal if you turn off your video for a second, but when you see the invitation to join him in a breakout room, please go there. So, yeah. Thank you. We had him backwards. I thought that she was at 1:30, he was at 2 o'clock. Uh-huh. We already went through them and read all your secret notes.
You can read my handwriting? That's amazing. That's my security protocol. Nobody can read my handwriting.
So, with nobody in custody, nobody in here, the three of them in here. I feel safer already. But nobody was up here on Friday. Who knew? I'm not gonna even look at you. You guys are both, I swear. We are where we're supposed to be. I logged on at 12:30, thinking we were actually gonna do something. There's a misdemeanor charge. Listen, lady. Did somebody go downstairs with him? I told him where to go, but so we go from 3 officers to 9. It's fine. Oh, here he is. Okay. Oh, maybe not. Hold on. Okay. So I just sent them into a breakout room. Yeah, I was not gonna come up with that. So got the files on Thursday, read them on Friday, made my notes, came in this morning, read them again for us to do this. No. Then Art came up so we could review probation, which was nice.
From Friday?
For a few going forward, how to get things to him if I want him specifically assigned, and if somebody needs a little bit more involved supervision. So it was nice. It's nice to have him back.
Who is your probation
Steve Hicks.
officer?
So there were giant strawberries at Kroger's again.
And strawberries there.
At Kroger.
And did you buy it?
He did.
What are you gonna do? What are you gonna do?
I am not gonna make anything.
If you don't think you can.
I do bake.
But I'm not.
They're just no, it's too hot. It's too hot to have the oven on. Just something different. You know, this is a time of year where food is plentiful, so you get what's on sale. He said strawberry shortcake, but I'm not feeling it. There's a fresh box of Bisquick on the counter. I just looked at it.
I spoke with the defense attorney on our 1:30. He is en route. Said he had called the court.
And I said I'm 5'8", and those are both untruths. Thank you for the update, though.
There's your update.
Yes. I put them in the breakout.
Oh, they are?
They are. No,
Why did I give us 2 o'clock?
I did too. It's the reverse.
I don't want to see it.
He's in? Yeah.
I don't know that I have to. What do you want me to say?
People know what you did last time.
If you do something that's wrong and we talk about it and you say, okay, I think that we're covered all the ground. The second time you do it and you go, okay, okay.
I remember you lit this guy up last time he was here. You know, he kept saying, sorry, Your Honor, sorry. Your Honor."
Don't apologize, just stop doing it. I'm mindful of other people's time, and I felt bad. We had to adjourn something last week, and I felt horrible because I had eaten up 90 minutes of somebody's day.
That's okay, I didn't know.
Listen, you. I keep thinking there's something belongs over here. It's just too much.
Like some of your class.
Probably not. Security risk, which I never thought about. Anything heavy or sharp on the bench.
They get that, but we're in trouble. They're not getting that. Probably
You say that, but
they're not.
I don't want to find out.
Unless maybe you have eight hearing loss.
Hush.
Because he can sit,
You got disconnected again.
but that guy's police sitting next to him. pushing the button.
I just reconnected your client and sent him back into the breakout.
Oh, thank you, Judge.
You're welcome, sir. See, this is why I went to school. You need to go too. You can just go back to room 1.
As soon as I see it, I'm there.
You don't have to see it. You can just go back to the breakout where you can reopen them.
Oh,
Yeah.
I'm looking.
You don't see it. You don't see a button at the bottom that says breakout
Oh,
rooms?
I've got it, Judge. Thank you.
If you reopen it, you can just go back to 1.
And his attorney.
Right. Yeah. I know. The clock is on the kitchen table. The clock is on the kitchen table. I keep forgetting to bring it in. So no, not glass in that corner. I don't know what.
No, I guess it makes sense.
Well, you figure I have enough heavy stuff.
Your bobblehead.
She's not actually a bobblehead. But then there's that glass cactus is over there, and that thing is not like.
You could go.
And then there's a marble egg over there. And then there's a slinky on my
Don't
desk.
be worried about that catch. You just worry about getting out that door.
Have you ever been at a courtroom or something like
No, I don't know. Do you? Have you?
that? I was at 36 for years.
That's if something doesn't happen, they're surprised.
Yeah, listen, when the guy was flipping off to Judge Ford and the officers jumped over the rail, not even on that case, on a different case, they jumped out of the jury box and got the guy.
What was he doing?
She had whatever ruled against him, and he was halfway out the door, and he said something flipped to her, and she called out to him, and he came back and was like charging towards her, and they just start coming out of the box, and I'm sitting there waiting for mine,
Whoa.
sitting there waiting for my civil case.
Did you kind of move?
No, it didn't involve me, absolutely not. Because they had a mixed docket at that time, so you could have traffic, criminal, and civil stuff all on the same docket. He dropped again. Mr. Green dropped out.
Hey, Heidi, do you still have those Jolly Rancher shoes?
I do.
Could I have? They know that's what you're doing.
Don't trust it if it's not a rapper
Not real, yeah.
covered in lint.
Couple of hairballs on it.
No, but thank you so very much, sir. I'm keeping it. You don't have a vehicle, but you're in a car. I can see you.
You called all on it.
I didn't mean to.
No, it's so funny. When he said that, I couldn't see his picture yet, and then his picture.
Well, when I came out and I saw 2 people in the waiting room, I was like, who's that? I knew one would be you, but I didn't know who the other would be. So yesterday, we're sitting, and this attorney was saying how they wear a blouse, a jacket, and shorts for court. And what do you wear? So wear a suit. Like a suit? I'm like, yeah, you saying it twice doesn't change. It is in fact a suit. But nobody can see you. I said, but people do see me and people know. I wear what I think you should wear. So I wear a suit, heels, and stockings. Mostly.
Well, I guess that if you're on video, and you're an attorney, I get that, I get what they said.
But that's how you wind up with the COVID creep. You wind up putting on 20 pounds because you're not putting on your skirts and your slacks, and you don't realize that that stuff doesn't fit anymore.
It is the COVID creep, what happens to you? Why?
Because you're not moving around. You're not going places. You're home and you're eating, you're snacking.
Oh, I can't, no. Can't even imagine.
It never happened like that for us. I mean, because I'm trying to think how did it go.
But
But
you can't even, you know, so that makes a difference if you're home alone. You know.
no, I'm just giving you a hard time. Go. Just go. Listen.
How does it go?
Yeah, he has a routine though. We used to play that. We had a record player in our room, so the three of us would play these albums and make our little routines and stuff. Yeah. And that is why the camera's not on me. So he's on camera now.
Who's that camera?
Rock out. That's what we should be playing music.
In between.
Ken's gonna do his routine. I can't even imagine.
No.
My mind won't even let me. A thing.
Well, you know, like paperwork to try the case. No. You have nothing in his hand. I mean,
Because you're smart. You have it all committed to memory. You have that eidetic memory.
Or he wanted to get up here with the staff.
You can't get in trouble. On Friday, what did I say? I don't lecture grown people. You already know how I feel. So what happens is when it's close and I know that you're disrespectful to the court, it's kind of,
we have a room.
I know we have a couple rooms. We have crackers, we have bottled water, we have, do we have any clothes? Something to sleep in, something comfy?
Gotta wear that suit. But you can use the suit coat for a pillow.
My dad had a t-shirt when I was a kid that said the whole Wayne County's finest bed and breakfast.
That's fine.
Oh, does he still have it?
He had a board too. It was a peg board of confiscated stuff, weapons they made, which as a little kid I thought was interesting. As I got older, I was like, that's super creepy. Really?
Sheriff's Department, yeah, we had 3 barracks out there back in '76 because of the overcrowding in the jail.
Mm-hmm.
We had barracks 14, 15, and 16 for the Sheriff's Department. We had like 128 in each barrel. It was just recycled planks up to the ceiling. It's divided into 4 quarters. And in the middle was restrooms, so anyone that had to use the bathroom, they could let them out, put them in there. We sat in the middle.
He was out there for a long time, and he used to actually live right down the street. They had the warden's house was right down the street from the prison on an old farm. That was an interesting building.
One time I was in the front office there where the first aid and all that is, because I got hurt. And they looked at it, said, "Oh, you better take it to St. Mary's."
They kept the administration building for a long time after they tore down everything
Yeah.
else.
Well, they had that little, like, when you come in the road,
Mhm.
they had that little, like, shack. And that's where the medical went.
Mr. Green, were you kicked out again?
No, I mean, we talk. He's coming back upstairs.
Okay.
We're ready, Judge.
Mr. King?
Mr. Green is going to waive.
King, K-I-N-G.
He's
I mean, as much as I enjoy your company.
I'll waive his right.
This is 210382 FY, State of Michigan versus Randy James Green. Appearances, please.
Good afternoon, Your Honor. Larry King for the people, P78774.
And good afternoon, Your Honor. Mark Garcia on behalf of Mr. Randy Green, who is present via Zoom. My P number is 39242.
Mr. Green, state your name for the record, please. Mr. Green? State your name for me, sir.
Randy
Mr. Green?
James Green.
Thank you. Today is the day and time set for the preliminary examination in this matter. How are we proceeding this afternoon?
Your Honor, I've had an opportunity to speak with Mr. Green.
Randy James Green. I'm sorry, I'm losing it. It's cutting in and out. Did you? Randy James Green. Randy James Green. I'm sorry, it's cutting out on me.
Thank you.
Mr. Green, in our
Randy
discussion,
James
we-
Green. I'm sorry, it's cutting out.
Hold on, Mr. Green. In any event, Judge, I did explain to Mr. Green that he has a statutory right to a preliminary examination. At that examination, the prosecutor would have to show two things.
It's
One, that
cutting out.
a crime was committed. The second, that he committed that crime. I believe he understands his right. He wishes to waive that exam and be bound over to circuit court. Is that correct, Mr. Green? Nod your head.
Yes, sir.
Mr. Green, were you able to hear your attorney just now?
Yes.
And you had the opportunity to discuss your statutory rights with him?
Yes.
And you wish to waive your preliminary examination?
Yes, ma'am.
And you're doing so freely and voluntarily?
Yes, ma'am.
You haven't been threatened in any way, promised anything?
No, ma'am.
Mr. Green, I'm
sorry,
passing a form to your attorney that he will sign to waive the preliminary examination. The next step in these proceedings will be your arraignment on the information. That will happen at the Frank Murphy Hall of Justice. Because you are not in custody, the date that you will be given today is September the 6th, 2021 at 9 a.m. If it
September
becomes a
6th?
different date, your attorney will be in contact with you.
Okay. You said September
Thank you.
6th, right, Your Honor?
Yes, sir.
Okay, thank you. I'm sorry.
Oh, are you going to sign for your client?
Yes, I was gonna say, may I state for the record, Mr. Green now has my phone number. We have agreed he will be contacting me in the next few days so that we can further discuss his case. Is that correct, Mr. Green?
Yes, sir.
No, my question to you, counsel, was were you going to sign the waiver on behalf of your client?
Mr. Green, may I sign my name on the waiver of preliminary exam? May I sign your name with your permission?
Yes, sir.
Thank you. Mr. King, any objection to the court signing the bind over?
No objection to the waiver of exam. Thank you, Your Honor.
Thank you. The request for waiver is signed. The court will sign it. Mr. Green, you'll be bound over as previously charged. Again, your next date will be the arraignment on the information down at the Frank Murphy Hall of Justice on September 6th. Thank you, sir. Your previously
Thank you.
entered bond with any conditions will continue. Anything else, Mr. King?
Nothing further for the people. Thank you,
Anything
Your
else on behalf of Mr. Green?
No, Your Honor, thank you.
Thank you. Mr. Green, we are all set. You may log off, sir.
Thank you so much.
Thank you, Judge, I appreciate it.
Good to see you.
Likewise.
We'll be in touch. Let me know what you need changed on that order, okay? Thank you.
I still don't like that. Because it feels weird.
I'll be back in just a moment.
Yes, sir. And it stops abruptly. Oh, you're recording on the machine? But you were? Because it didn't even.
I think we're ready on our 1:30.
This is 210452FY, State of Michigan versus Devontae Jarrell Gibson. Appearances, please.
Good afternoon again, Your Honor. Larry King for the people, P78774.
Mayor, please quote you on Tyrone Baker, plea number 62647, appearing from the Neighborhood Defender Service of Detroit on behalf of Mr. Devontae Gibson, who's present to my right. And Your Honor, we are prepared to proceed.
Could you state your name for me, please, sir?
Devontae Gibson.
Thank you. Today is the day and time set for the preliminary examination in this matter. Mr. King, how are we proceeding this afternoon?
But unfortunately, our complaining witness is not present. She was served with a subpoena. She was made aware multiple times of today's court date. However, she is not here. I cannot proceed on count 1 without her. That being said, count 2 is a misdemeanor. So if there were to be a motion from defense and court was to grant such a motion, I ask that the misdemeanor be kept alive.
Thank you. Mr. Bickert,
I certainly would make the motion to dismiss the matter.
as to both counts?
As to both counts, Your Honor, my simple argument to that would just be that we are speaking about the same complainant. I mean, in essence, what we'd be asking is to, my client to come back. I understand that my client's not entitled to an exam on the misdemeanor, so I do understand and appreciate that as well, Your Honor. But I would ask the case to be dismissed without prejudice as to both counts.
Anything else, Mr. King?
No, Your Honor, as defense counsel stated, there's no jurisdiction here over the misdemeanor matter. So I do ask if the court is inclined to dismiss the felony to set the misdemeanor for a misdemeanor pretrial.
The court will grant defense motion as to the felony only. We'll schedule the misdemeanor for a pretrial. Marianne will look at the docket for the next available Romulus pretrial date. Okay.
Is it just domestic?
It is.
Okay, thank you.
Thank you. Mr. Bickert, Mr. Gibson, if you want to have a seat, Mary Ann just went to go get a date.
Okay, I understand.
You can sit right where you were unless you just want to sit in the audience. Doesn't matter to me.
14 at 9.
With whom? Thank you. Pre-trial on the only remaining count, that being the domestic violence misdemeanor, will be on September 14, 2021 at 9 a.m. That will be by Zoom with Judge Oakley. Mr. Gibson's bond will continue in the interim, which was $10,000 personal with a no contact order with the victim. Anything else, Mr. King?
No, Your Honor, thank you.
Anything else, Mr. Bicker?
John, did you put it at 9 a.m.?
I did.
Okay, all right, thank you.
Thank you. Have a good day.
Thank you all.
It's 2:03. Is Ms. Robinson here?
I can see you.
Thank you, sir.
Jason's in here, that he needs to change his board. Should you do that? Window downstairs, like window downstairs.
Thank you.
Can I approach her?
Absolutely.
I'm gonna see if with the 2 o'clock, you're just consulting with Frank, you let her know.
Yes.
Thank you.
not another group fix.
Really? Oh, I know. I don't know. Yeah, Mom and I, we're gonna go to Harvest Springs, and then Alex and Ruby are gonna walk. And then the cat was available Thursday and Friday, she's gone. That was really good. So. Mhm. So it's nice after that.
You just call, let you know.
Cause you're not.
Oh, you're my boss.
No, I'm really boss.
Me either. You're mine. Who knows?
You get it mixed up. Is that what
No.
you're?
He doesn't say with Jamie all day, don't get involved. He does.
What's that?
From my buddy.
You have his back all day long.
Missed me when I'm gone, I miss him when.
You are, you lost.
You're the perfect little angel. He's never to be found when you're not here. And then if I come up, he was either gonna speed up on her desk or on the shot's desk. Jamie. But he's got sick close to the desk.
Oh my God. Oh, I should have seen that.
I was telling my dad, you know, they used to do that. Their first pair of baby shoes, they had Brian, people would put them over their mirror. I said, hey, if you use your shoes, I got a pair like that hanging on my mirror.
Wonder when he gets to their.
A booster seat.
Or no, the horses or something.
Yeah. You just want to get us home.
It was actually about 10 days. Exactly.
I think it was,
It's
wasn't that her sheet signal?
She didn't cut it short.
Oh, cause she didn't let it look like brains.
Right.
Yeah.
Yeah, I think it was.
How do you remember that? You don't remember when you got yours?
It's actually Tuesday.
I can tell you what I ate.
It was
for dinner last night.
It was August. But she didn't,
Yeah, it was only it was 3 weeks.
but she only cut off that much. She was that one. You remember lumps? You remember lumps? Lumps?
No. What was it? What is it?
It's a
Restaurant?
restaurant.
It was kind of a high class.
That's why I don't remember.
That's one. They didn't have mustard, they had like mustard in a jar. Yeah, I guess. Now you couldn't do it for sanitary reasons. But some of the guys that play hockey didn't have. They take the teeth out, put it in there.
Oh, no.
You know, that's why we can't eat the animals option. Carolyn, that's.
So I saw clean it.
Why?
Because her and I were in the the one day his teeth out, he was dipping them in the car. And you know what she said? She said, I know darn well I did that water. I took the teeth in. So she won't eat them.
How are they doing? Are they still open?
Now we're in office.
Yeah, because you can't. That's the shame.
Mr. King and then, his attorney home.
Oh.
It's all one jumper, it's one piece jumper.
What do you guys do? That this weekend.
So it's Tuesday.
Yeah, so I guess I will be here next week. Right? So unfortunately, I will be. Yeah, it's in
2 weeks.
2 weeks. Oh, I gotta say, I thought it was next.
Let's go back to school. Summer went up that. She's been back a week.
How's she doing?
She was back.
Oh, really? Was she cool?
Every
With
day.
the kids?
Every day was nice.
Does she go alone also?
Yeah, there's probably 10 people out there, no, maybe 25 people she knows.
Oh, so
It's kind of like,
yeah.
should have moved there.
Oh, Ken. I really, man, I would have been so happy. I mean, I love the house.
Yeah.
Still, the location.
And plus you don't have no more grass, kind of running around, snow shoveling.
Yeah.
Something.
Can we plan it? Good to see you guys. Do you have them okay?
Maybe next time.
Yeah.
Have them okay?
Is Ms. Robinson ready?
They're here talking. The two attorneys are talking. They said we were right back on schedule.
Why do you say that stuff out loud? But that just makes it become this thing.
Tell me again, tell the judge said, no. I'd like to say it.
Why are you lying on me?
Because then it comes up. If I tell the judge is ready.
Tim just laughs.
I know.
Six.
This, does he need to come on the 3 and then ask for counsel, not ask? Like,
They'll have attorneys available that day.
all right, that's exactly right. Thank you.
You're welcome.
Your Honor, I understand it's the bathroom break time for everybody, and I'm not excluded from that. I'm gonna be right back.
Oh, I didn't get that memo. Wait a minute.
No, I didn't tell you that.
He has all the energy after his nap. I was in at the beginning of this month. I said.
She'd like to,
Good afternoon, Ms. Robinson.
How are you?
I am wonderful. How are you?
I'm doing well, thank you.
Did you tell them what I said?
How are you?
No, you did not. She said, you have a lot of energy.
I didn't know.
Why not? What were we doing this morning?
Why do you laugh?
Because I've been in this building since 8 o'clock this morning.
At 1 o'clock, everything else. And I have
So
to
you
give-
back into 1 o'clock.
Yeah, but I have to let those guys eat lunch too, so I only take half an hour on days we have stuff served.
So we should start at 1:30? Is that what you're telling me?
You can start there you want, you're the judge. I'll work around you.
He's gonna be dragging tonight.
I told Tim, I'm kind of tired. If he didn't
With
get
3
one-
exams, really? With 3 exams, you're tired? But you knew that last night. That you weren't gonna get napped.
Nope, I wasn't here Thursday.
So
Friday.
take your 10:30 nap.
That's too early.
Go online and look at our document.
On weekends. That will never happen, right?
I have no idea. She's a computer person. I wanted to get my game set up. You know, where they just take
Auto
it
pay.
over, yeah. And I tried it, but I mean, it took me 5 minutes to get it all set up.
Are you that guy?
Am I?
You're that guy?
Yeah, yeah. I'm stuck in old school.
You're not that old.
Nowhere near. Not as old
You people. This is 210512FY, State of Michigan versus Ronald Allen Molman III. Appearances, please.
Good afternoon, Your Honor. Larry King for the people, P78774.
Good afternoon, everyone, and Judge Brandy Robinson of the Neighborhood Defender Service. My bar number is 66895, and I'm here on behalf of and with Ronald Holman, who stands to my right for purposes of the record.
State your name for me, please, sir. Thank you. May I have a seat? Today is a day and time set for the preliminary examination in this matter. Mr. Molman is charged with count 1, carrying concealed weapon, and count 2, aggravated stalking. Mr. King, are the people ready to proceed?
People are prepared to proceed, Your Honor.
Ms. Robinson, is the defendant ready to proceed?
Yes, Judge, we are.
Are there any preliminary matters to be disposed of, Mr. King?
There are no preliminary matters, Your Honor.
Ms. Robinson, from your point of view, are there any preliminary matters to be disposed of?
No, Judge.
Ready?
Yes, Your Honor, as I proceed up, before I call my first witness, I would move for admission of this document. I'd like it marked as People's Proposed 1. It is a document under seal, preliminary, or from the Third Circuit Court. It is a personal protection order, which was granted ex parte, protecting Ms. Brianna Cottrell from Mr. Ronald Allen Molman. I'd like to have that marked as People's Proposed 1 and move for a submission of the
Thank you. Any objection to its admission, Ms. Robinson?
Judge, I recognize that there is a statute that allows people to proceed in this fashion. I would just know my objection for the record.
Thank you. Mr. King, it's been received. Are you ready to call your first witness?
Yes, Your Honor. I'd call Officer Perkins to the stand.
If you could stop right here at the lectern for me, please, sir. At the lectern, spell your first and last name for the court reporter.
BRYANPERKINS.
Do you swear from testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Come up the ramp and have a seat in this purple chair, please.
Good afternoon, officer.
Good afternoon.
So I know the uniform kind of gives it away, but for the record of the court, could you please tell us what you do for a living?
I'm a police officer with the city of Romulus.
And how long have you been working in police?
9.5 years.
And was all of that with Romulus?
Yes, sir.
Were you working on March the 23rd of this year, 2021?
I was.
Okay, what shift were you working?
Afternoon shift.
Sir, did there come a time when you were dispatched to 32801 Ecorse Road in the city of Romulus?
Yes, sir.
Is that within Wayne County?
Yes, sir.
And what is at that location, sir?
It is the Amazon facility.
Okay. And about what time do you recall being dispatched there?
I'd have to refer to my notes if I can.
Did you record, would referring to your notes refresh your recollection as to the question of what time you were called there?
Yes, sir.
I'd ask that the officer be allowed to refer to his notes to recall his recollection.
Yes, sir.
Okay. Then look up, don't testify from your notes, only use them for refresh your recollection.
Okay.
And then look up to me when you're done.
Okay. Approximately 6 o'clock.
Approximately 6 o'clock?
Yeah.
AM or PM?
PM.
And what was the nature of the dispatch that led you to that location?
Your Honor, I would object for any answer that places hearsay into the record.
And Your Honor, I would simply say this is not being offered for the truth of the matter asserted. This is effect on the listener. He was dispatched to the location. So the information as to why he was dispatched is not offered for the truth of the matter asserted, rather offered to explain his actions.
Judge, we will stipulate to the nature of the call made to respond to this. I don't think the content of those communications is admissible, and I think it will be hearsay. So I object.
And Your Honor, I understand what defense is saying. However, I'm not bound to accept such a stipulation. I believe it would be necessary. I believe it is necessary for the officer to explain to the court as to what called him to that location. Simply asking him what the nature of the call is. He may even be able to answer that without putting words in anyone else's mouth, although I would say that it's not hearsay.
Objections overruled. You may answer the question.
What was the nature of the dispatch that brought you to that location?
It was a weapons violation complaint.
Okay. So can you talk to us about how this location is laid out?
It's a large facility, large parking lot. It's off of E-course, or you can get to it from Vining.
And when you arrived at the location, what, if anything, did you do?
At first, we made contact with the security at the location.
Okay.
Who directed us to where we needed to go.
Okay. So where did security direct you?
To the northeast side of the parking lot.
Okay. And what, if anything, did you observe in the northeast side of the parking lot?
I observed a black Dodge Avenger that was described by the security.
Okay. And what did you do next?
We made contact with the occupant inside.
Okay. And do you recall who the occupant of the vehicle was?
Yes.
And who was the occupant of the vehicle?
Ronald Mullen.
And the person that you made contact with that day that you identified as Ronald Mullen, do you see him present in court today?
I do.
And could you please tell the court where he's seated and what he is wearing?
Next to the defense with the white shirt on.
Record reflect identification?
Yes, sir.
Was anyone else present with Mr. Mullen at this time?
No.
Okay. What did you do next, sir?
My partner was on the passenger side of the vehicle. I was the contact officer on the driver's side of the vehicle. As we approached, my partner immediately saw a fire.
Objection, Judge, to what his partner saw.
Objection sustained.
Okay. You and your partner both approached the vehicle, is that correct?
Correct.
And what did you do after you approached the vehicle?
Instructed the defendant to exit the vehicle.
Okay. And then what did you do, sir?
After I learned that there was a firearm in the vehicle, we exited him out of the vehicle. I placed him in handcuffs.
And after you,
I couldn't hear the last part of his answer.
Oh, I'm sorry.
Voice trailed off.
We had him exit the vehicle after I learned that there was a firearm in the vehicle, and then I placed him in handcuffs.
and how did you learn there was a firearm in the vehicle?
My partner.
So what was the next thing that you did after the defendant was placed in handcuffs?
I advised him, I asked him if he had a CPL. He responded no. I advised him that we had to obviously investigate the situation. And he was constantly telling me the PPO's fake, the PPO's fake.
Okay. Did he say anything else regarding this PPO?
He said that it was in the glove box and that he was encouraging me to go grab it to see for myself that it was a false PPO.
Okay. So he was asking you to go into his vehicle?
Yes.
Okay. And what did you do then, sir?
He instructed me that the PPO was in his glove box and again, continuously encouraged me to go get that, retrieve it. So then I would retrieve the PPO.
Okay. And what did you do?
After I retrieved the PPO.
Oh, so I'm skipping a step here. He encouraged you to go into the glove box and retrieve the PPO. What did you do?
That's right. I retrieved the PPO.
Okay. So did you enter his vehicle?
Yes.
Okay. How did you enter his vehicle?
Through the passenger door.
Okay. And while inside of his vehicle, did you perform a search?
Of the glove box and to retrieve the firearm.
Okay. So let's talk about the glove box first.
Okay.
What, if anything, did you locate in the glove box?
The PPO.
Okay. Do you recall the parties listed on the PPO?
It was Ronald Molman and then our victim.
Okay. If you saw that PPO again, would you recognize it?
Yes.
May I retrieve people's warrant?
Yes, sir.
And Judge, I'm going to object at this point. I believe that more foundation needs to be laid as to the exact document that the officer saw versus what the people are getting ready to introduce. And so he says, I saw the PPO. I think we need more information about that from the officer before he can testify from a document that may very well be different.
If I may, Your Honor.
Please.
The purpose of showing this document to the officer is to ask him the very question of, is this copy of this document the same as what you found in the glove box? I'm asking him to say, hey, look at this. Think back to what you saw in the glove box. Is this what you saw in the glove box? It's identification of a document, but by the way, has already been admitted as an exhibit. So the officer did testify that he recovered a document purporting to be a PPO listing the defendant's name and the complaining witness's name. And this is the PPO that's in question in this case. So I'm simply planning on presenting this document to him and asking him if this document matches the document that he purportedly retrieved from the glove box that day. So I think the objection to lack of foundation is, if anything, premature, because I actually haven't asked the foundational question yet because I haven't shown him the document yet. This is an already admitted exhibit. I'm simply asking him to take this exhibit, recall the thing that he collected, and tell me if this is one and the same.
Anything else, ma'am?
Judge, I can cover this on cross-examination, but again, I think the objection remains. So.
Objection overruled. You may proceed, Mr. King.
So I'm going to hand you what's been marked as People's Admitted Exhibit 1. Take a look at that document. Have you seen a copy of this document before?
I don't know if I saw this exact copy.
Not that exact copy, but have you seen that document?
Yes.
You've seen that document before, a different copy of that document?
The petition for the PPO is what I saw.
Okay. And it was that PPO? With those two parties?
Yes.
Okay.
Sorry.
Thank you. So just to be clear, the document that you saw listed the defendant and listed also a Miss Brianne Cortez. Correct. So aside from recovering this document from the glove box, you mentioned that you also retrieved the weapon. Can you tell the court about that? Where did you locate the weapon?
So I located the firearm in between the center console and the driver's seat. So obviously I retrieved that firearm. The firearm the magazine was loaded with live rounds, and I racked the slide to make sure that there was not one in the chamber. There was not a round in the chamber.
What type of weapon are we talking about, sir?
I'd have to refer to my notes.
Can you, if it's okay, could you refresh your recollection by referring to your notes and then look up to me when your recollection is refreshed?
I believe it was a silver Taurus.
And what was done with that weapon?
I immediately secured that in my waistband, and until I got to the station where I processed it as evidence.
And what did you do after you retrieved both the weapon and the documents from the vehicle?
So I immediately, after I grabbed the PPO, I gave it to my sergeant who was standing by with the defendant as me and my partner went inside the Amazon to conduct our investigation.
Did you make contact with anybody else during the course of your investigation?
Yes.
And who did you make contact with?
Brianne.
Okay, so you made contact with Brianna Cortrell?
Correct.
Where was that contact?
That was inside, it's inside Amazon. Looked like a room that they just brought her to while she was waiting with their staff.
How did she appear when you made contact with her?
She appeared scared, frightened.
Okay, what specific things that she was doing or saying or how she was acting are leading you to believe that she felt frightened?
I think she was holding back tears as she was.
I'm going to object to, I think she was holding back tears.
She was holding back. She was holding back tears while she was speaking to my partner.
Okay. Anything else about her mannerisms?
She just wanted to know where he was.
Okay. After speaking with Ms. Cortrell, what did you do?
After speaking with her, we collected our witness statements, and then at that time, we took the defendant to our police department.
I don't have any further questions of this witness. I would again return the already submitted exhibit.
Thank you.
Thank you.
Ms. Robinson.
Thank you. Judge, may I, please utilize the exhibit, just consider it the witness?
Yes, ma'am.
Thank you. Okay, tell me your name again.
It's okay. Officer Perkins.
Perfect, okay. How are you today?
I'm good. How are you?
I'm doing fine, thank you. Now, you hesitated a little bit in that testimony about whether or not you had seen the document.
Correct.
Why?
I was confused as to if he's asking me if this is the document that I saw, like the physical copy of it.
Okay, what was confusing to you about it?
Again, I thought he was asking me if this was like the real copy of what I don't know if it was the physical copy of what I saw.
Okay, now you said the word petition when you answered the question. You said that you saw the petition,
Right.
right?
Mhm.
Because you did see a petition that day, correct?
Is a petition of a PPO.
Okay, Judge, may I approach the witness?
Yes, ma'am.
And when you say it was a petition, tell me why you thought petition.
To be honest, I saw the word petition on it, and I'm not sure if it was I didn't get like a long enough look at it to know if it was a served copy of a PPO or if this was a petition for a PPO.
Okay, and you saw the word petition across the top of the document, right?
I don't recall if it was on the top or where it was specifically.
Fair enough to say that it was something that you saw right away? when you looked at
Petition,
it?
yeah.
Okay, you didn't read the document in detail, though? Okay. I'm going to approach and ask you to look again at this document.
Mhm.
Especially at the caption. Can you read what the caption says? At the top?
Personal protection order, ex parte domestic relationship.
Okay, so that says personal protection order, correct?
Correct.
But what you saw that day was a petition, correct?
A petition.
Okay, and you said you actually handled some documents that you recovered from the glove box that day, right?
So I grabbed the document and then, like I said, gave it to my sergeant as
Okay.
we investigated further.
Okay, and that was probably 6 or 7 pages, right? Were the documents that you were looking through that day?
I don't recall how many pages it was.
Okay, but it wasn't just 1 page, right?
No.
And it was more than 2, right?
Again, I don't recall how many pages it was.
Okay. It was your impression that day that what you were looking at was a document that she had applied for to get the PPO, correct?
At that point, I wasn't sure if this had been served or, because like I said, he was encouraging me to go read through it. So,
Right.
So I wasn't.
I'm sorry.
No, it's okay.
And I definitely am not trying to quibble with you, but, I'm not talking specifically about the service, but just about what the document was. It was your impression, standing there that day, that you were looking at the document that she had used to apply for, that what she had filled out, correct?
Yeah, I would say yes.
Not necessarily the court order, right?
Correct.
Okay. And you said that you grabbed those documents and you gave them to a sergeant?
Yes.
Okay, and you don't have those documents with you here in court today?
Can I look through?
Sure.
I do.
Okay. Can I take a look at them, please?
Yes, ma'am. I'm not sure where it ends.
If you could just pass all papers that you have.
That's where it starts.
Thank you. Okay, and at the top of this document, can you tell me, actually, let me just take a look. I was about to lick my finger like we don't.
No,
have
you
COVID.
weren't. Are
I
you
was.
serious?
I was. Lord, forgive me, Judge, forgive me. Excuse me one moment.
I would have been done.
I would just ask to look at those before the officer if I could. I don't have any.
gonna hand you back 4 pages, which look to be part of your police
Yeah, no
report
problem.
for the purpose of the record.
Thank you.
Okay, I'm gonna hand these back to you, officer. Can you please read the caption of the top of that document? And by the caption, I mean the capital words.
Petition for personal protection order.
Okay, that does not say petition, personal protection order,
Correct.
correct? And how many pages are in that document?
10.
10 pages, all right. And that's what you were reviewing from the side of the car that day, correct?
Yes.
Not this personal protection order, correct?
There's a petition.
Okay, very well. Judge, I'm gonna return.
Thank you.
documents to the court. Now, I want to ask you just a few questions about your first contact with Mr. Moman that day.
Yes, ma'am.
So it was yourself and your partner. What's your partner's name again?
Officer Reyna.
Raymond, okay.
It's Reyna.
Oh, Reyna?
Yep,
So
Reyna.
Reyna.
Yes.
Okay, very well. And you had to fill out a use of force report with regard to this case, correct?
My partner did,
Your partner had to fill out a use of force report. What was the reason for that?
because he drew his weapon.
Okay, he drew his weapon when?
Upon initial approach.
Okay,
When he saw
so,
the firearm.
okay, so when did you and Officer Reyna approach Mr. Moman's car at the same time?
Yes,
Okay, and you were on the driver's side,
yes, ma'am.
Officer Reyna was on the passenger side,
Yes, ma'am.
and Officer Reyna drew his weapon.
Correct.
And this wasn't like a friendly first encounter. Would you agree with me?
I would say it was unfriendly. I think we were just trying to figure out what's going on.
Okay, do you remember yourself and your officer saying to Mr. Moman, "Don't fucking move, don't move"?
If that's what we said,
You don't remember?
I don't remember.
Okay, have you reviewed your body worn camera in this case?
No.
All right, Judge, would you recognize your body? Let me back up a few steps. You wear a body worn camera as part of your
Yes.
standard issue uniform, correct?
Mhm.
And that body worn camera is activated when you have encounters with citizens, correct? And were you wearing your body worn camera that day?
I was.
And was the body worn camera functional?
Yes.
Okay, and did you specifically download your body worn camera after this incident?
No.
Okay.
So the process with the body cameras is at the end of our shift, we plug them in, which I believe, uploads all the footage. And then we have a record supervisor who will download, body camera footage for
Okay.
individual cases.
Okay, so it's something that just sort of happens automatically.
Yes, ma'am.
And you didn't have any indication that it didn't happen in this case, right?
I wouldn't think so, no.
Okay, all right. I would like to refresh your recollection with what I'm going to call Defense Proposed Exhibit A.
Mr. King?
Your Honor, I would like to object to this line of questioning. I believe we've gone beyond the scope necessary for preliminary examination. We're talking about use of force by another officer, and I don't understand how that's relevant to prove or disprove whether or not there was a concealed weapon in the vehicle and whether or not there were PPO violations which caused fear in our complaining witness. So I don't understand the relevance of this line of questioning as to the exam.
Judge, I believe that the people just elicited testimony that they are going to rely upon, that my client volunteered that he had a PPO and all of this stuff. And I think it's relevant as to the voluntariness of that statement and whether or not it should be admissible evidence that the court can rely upon. So I think it's 100% relevant, especially with weapons drawn.
The voluntariness of his statement just regarding the gun and the paperwork in the glove box?
Yes, and specifically, Judge, I believe that this was, he was in custody at the time, he was entitled to Miranda warnings. And so he should not, they should not have been asking them these questions without Miranda warnings. And so I think the circumstances of the arrest is relevant for that. And to the extent that the court has to make a decision based only on admissible evidence, I think it is something that I'm entitled to explore at this stage. And I don't have a whole lot more, but I do have a few questions, and I think it's relevant.
Mr. King is standing up again, but just so we're clear, your position is right now that there's something on the body worn camera some conversation or some statement that made it so that Mr. Moman was in custody before I have a gun and get the petition out of the,
That's correct. Judge.
okay. Mr. King,
Now that I understand the purposes for which she's wanting to see the body worn camera, I guess I understand where she's going with this now. However, I would say if we're going to go down the road of an entire Walker hearing, it would have been good to have that done before the examination. That being said, I withdraw my objection.
thank you. Do you have it queued up?
I do.
You, Mr. Moman, you should be able to see it on the, oh, are you plugged into the podium?
I can be, Judge. Oh, yeah.
There's,
So-
I thought there was a plug up there too, where you were standing, but
Because we're in a technological courtroom and y'all can see it without me having to
I'll be able to
present
see
it
that.
directly. I do
you'll
have
be,
it.
it'll be there for you. She'll connect where she is. He'll see it. I'll see it. Is that on still? Is it sleep or did you turn it off? Why are you trying to break our nice stuff? It'll
It's
come on.
fancy. I
It
was
should
trying
come
to
on
turn
in
it on.
just a second. When she hits play, it should start going.
Kelly's breaking equipment.
The only thing, Judge, is that I would need an HDMI cord. And I don't know if the court has. one
She's
or not.
bringing you one. Yeah, officer's bringing you one.
Oh, perfect. Thank you.
Thank you, Tim. I was looking at you. I thought you had one over there, Marianne. What did you say?
Yeah.
I thought Tim left one. I thought Fred left one up here from before. Oh, wait, there's a, okay.
All right. I am hooked up. Oh.
Should they show on, oh, there it is.
Everybody should have it up now. Okay.
This is amazing. Okay, so for the record, I will play the entire first minute, the first 30 seconds. I don't believe we'll have audio. Now, officer, before I go forward, do you recognize this as the scene of Amazon where you were going to respond?
Yes,
Okay, and do you see the Dodge vendor that you referenced
I
on
do.
your direct testimony? Okay, and is this a fair and accurate depiction of the scene as it appeared to you that day?
yes.
Okay. And so picking back up for the record at timestamp 0034 on the video. All right, I'm gonna stop the video at 117. So to revisit the question, you recall yourself and your officer saying to Mr. Moman, don't move, don't fucking move. And would you agree with me that immediately after this part of the video that we see, and again, we stopped at 117, Mr. Molman was taken into handcuffs?
He was placed in handcuffs, yes.
He was placed in handcuffs, okay. And it was after he was placed in handcuffs and after the weapon was drawn by your partner and after the words "don't fucking move" that he was then asked questions by yourself and or your partner, correct?
As far as the CPL goes, I believe in the process, I was asking not to get a CPL.
Okay, and he was also asked questions after this point regarding whether or not he had a PPO against him, correct?
I'd have to watch the video.
Okay.
I honestly don't remember.
Okay, you don't recall. So Judge, I'd like to refresh the officer's recollection with an additional section from this video, if I may.
No objection.
How long is it?
Just a few minutes, really.
Okay.
It's pretty, it happens pretty.
Okay.
Thank you. So picking up at 117.
There you go. You want to have a firearm? Get a CPL? What's the gun at? I believe it's right in my phone. Got a PPO against you? I believe it's safe. You know, well, you don't have to get mail to you, and
I'm gonna stop the video now at 2 minutes and 6 seconds. So did you hear that question from him? Two questions. Do you have a CPL?
Correct.
Yes, you heard that question?
Yes.
Okay, and did you hear him give an answer?
Yes.
Okay, and that answer was no, correct? And then did you hear him being asked, do you have a PPO?
Correct.
And you heard him say, I believe it's fake.
Correct.
Correct? And then after that, you heard the question, so you acknowledge the existence of what you believe to be a fake PPO. And he says how he believes the PPO has to be served.
Correct.
Okay. If I may have a moment, Judge.
Yes, ma'am.
Judge, I don't have any further questions at this point.
Thank you. Mr. King.
Just a second, Your Honor. No further questions.
Thank you. Officer Perkins, you can step down. Mr. King, your next witness.
Calling Brianne Courtrout.
Tim, could you see the video playing back there? Were you able to see the video playing back there? Yeah. No, there's they feed them, but the power's not on. Okay. Good afternoon.
Hi.
Could you spell your first and last name for me, please?
You said spell it?
Yes, please.
BRIANNCOTRELL.
Raise your right hand for me. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you. You're going to come up this little ramp. Have a seat in this purple chair, please. And what's gonna happen is my court reporter is recording what you're saying, so you're gonna speak into the microphone, okay? From time to time, I'll look over to her and she might tell me that she can't hear you or that she's not picking you up, and I'll let you know, okay?
Okay.
Thank you. Mr. King?
Thank you, Your Honor. Ms. Cortrell, I want you to think back to March of this year, 2021. Were you working at that time?
Yes.
And where did you work?
Amazon.
Where's that located?
Course Road.
I'm sorry, Ms. Cottrell, could you pull the microphone to, yep.
Got to make things easy on Mary Ann so she can transcribe this. So say that again.
It's on Course Road.
Is that in Romulus?
Yes.
Okay. Do you know a person named Ronald Allen Molman?
Yes.
Okay. How do you know Mr. Molman?
We dated.
When did you date Mr. Molman?
Like, when did I start dating?
Yeah, when did you meet him? When was the first time? When did you meet Mr. Molman?
2015.
Did there come a time when the relationship ended?
Yes.
And when was that?
I don't know the exact date, but it was probably about 6 months ago now.
Okay. Was it before March of this year?
Yes.
Had you obtained a personal protection order against Mr. Molman?
Yes.
Why did you obtain that personal protection order?
Because I was scared. I didn't think that he would leave me alone if I didn't have one.
Okay. And what did you do when you obtained that personal protection order? What if anything, did you do to give Mr. Molman notice that he had this thing?
We got it sent to his house.
I'm sorry, Ms. Cottrell, 1 second, please.
I believe it's a leading question. I think he can ask this witness what she did, what steps she took and so forth. But I don't think he can suggest even a direction of her question. I think it's a leading question.
Your Honor, as the court's aware, leading question is a question that suggests the answer within the question. So what, if anything, did you do to put Mr. Molman on notice is not a leading question. She's free to answer this in any way she'd like.
Ms. Robinson?
Judge, he's asking her specifically about what she did with a particular portion of their proofs. And I think it is leading and suggests, and frankly, it suggests facts not in evidence, right? To the extent that she did anything at all to put him on notice. So
Your objection sustained. Mr. King, I'll have you rephrase your question.
Did you take steps to notify Mr. Molman?
Judge, it's the same question.
It's a yes or no. Did you take any steps to notify? It is a yes or no question, Your Honor. There's an example would be, isn't it true that you walked up to him and handed it to him and he said, thank you? Isn't it true that you placed it in certified mail? Isn't it true that you called him and told him? Isn't it true that you went to the office? All of those are leading questions because they suggest the answer within the question. What, if anything, did you do to notify him is not a leading question. She could say, I did nothing. She could say, I did any number of things. But the answer to the question is not included within the question. So it's not in and of itself a leading question. It's simply asking her if she took steps to notify him. Yes, no, I don't know, maybe, whatever she wants to answer. And then I would follow that with what steps did you take? But I don't believe any of those are leading questions.
Judge, again, I do still believe it assumes facts not in evidence. I think it's just a different way of wording the same thing he asked before.
Mr. King, I'm going to concur with Ms. Robinson insofar as you might want to take a couple more steps to get where you're going in terms of you.
So how did you get this PPO?
I went to the police station and filled out a report.
Okay. And what did you do after that?
I got it sent to his house. I went to the post office and wrote down his address.
What exactly did you have sent to his home?
The PPO, the papers that they gave me.
Okay. Where did you get these papers from?
I think it was in the mail.
Okay, where did you get them from?
Objection is speculation.
If you recall.
I'm not too sure.
But you mailed him documents, you
Yes.
said? Do you recall what exact documents you mailed him?
I know it was like saying that I got a PPO and like with his name on it.
Okay. Did it have your name on it as well?
Yes.
And when did you do that?
I don't know the exact date, so it was probably
Objection is speculation.
What month did you do that in?
March.
Okay. Do you recall if it was early, mid, or late March?
I think early.
Okay.
Objection is speculation, Judge.
Do you recall when in relation to you obtaining the PPO you did that? Like, you said you obtained the PPO. Do you recall how much time after that elapsed before you put these in?
I'm not sure. I know I did it as soon as I got it.
Okay. All right. Now, you stated that you worked at Amazon, right?
Yes.
What shift do you work at Amazon?
Sunday through Wednesday, 7 to 5:30.
So I want to talk to you about March the 22nd of this year and March the 23rd of this year. Anything unusual about those dates stand out in your memory?
Yes.
Okay. Talk to me about March the 22nd. Were you working that day?
Yes.
Did something unusual occur at work?
Yes.
And what was that, ma'am?
I was walking to my car to leave, and I seen Ronnie's car pulling in, and he parked, and I was trying to get in my car fast, and he was behind my car waiting for me.
Okay. So did he say anything?
Yes.
What, if anything, what did he say?
That he was sorry and he wanted to fix it, work it out.
Okay. What did he do after that?
I told him I had to leave because I was on the phone with my sister,
Okay.
so I left.
Okay. And what did he do when you left?
We were driving the same way, nothing really. He just texted and said that he wanted to work it out.
He texted you?
Yes.
Okay. How did that contact make you feel?
Scared, like I didn't know what to do.
Okay. Had you ever seen him at that location before then?
Like at my work?
Yeah.
Whenever we were together, yes.
Okay. Did he work there?
No.
Okay. Let's go to the next date then, on the 23rd of March. Did something out of the ordinary happen at work that day?
Yes.
And what was that?
Him being at my work again.
Tell us about that.
Okay. So I had a manager walk me to my car this day.
And why did you have a manager walk you to your car?
Because I
Objection
told.
to the relevance.
Your Honor, aggravated stalking requires that we show not only that a reasonable person would be in fear, but that this person was subjectively in fear. So this goes directly to her level of fear and her state of mind related to the contact that happened the day before and related to the contact that we're going to be getting into. So it goes directly to her state of mind, which is an element of the charge crime.
I'll leave it to the court's discretion.
Objection overruled, ma'am. You may answer the question.
So why did you have that manager walk you to your car?
Because I told HR that I had a PPO.
Objection, I'm sorry, objection to hearsay, Judge.
Do you-
So can you answer it without talking about anything else anybody said or anything you
okay.
told anybody else?
Okay.
Just answer the simple question of why you made that decision to request that manager walk you to your car.
Because I had a feeling that he might be out there again,
Okay.
and so I had the manager walk me to my car.
Were you scared?
Yes.
Objection to leading, Judge.
Were you scared?
Yes, that suggests the answer.
Again, Your Honor, there's a common misconception that every yes or no question is a leading question. And yes or no questions are not by definition leading questions. She is free to answer this question in any number of ways. It does not direct her exactly to the answer that I'm speaking of.
Judge, the people just made a record about the elements of defense and what they have to prove, and then they're gonna say, did you feel these things that fulfill the statutory elements? It's a leading question, it suggests the answer. You can ask the witness how she felt, and she can testify to that. But to say, were you scared, were you angry, were you frustrated, were you happy? Suggest an answer, I object.
I'll overrule your objection. You may answer the question, ma'am.
I was scared.
And what, if anything, happened after you left work with the manager?
You said what happened?
You left work with the manager.
Well, he walked me to my car.
Okay.
I got into my car,
And then what happened?
and I thought I was fine. I was plugging in my music, finding a song, and then Ronnie comes into my front seat of my car and shuts the door.
Okay. And what happened next?
He said that he wanted to talk, and I said, no, I have a PPO. You have to leave. And he said, no, like it's fake. No, you don't.
And then what did he do?
He buckled up because I told him to get out. And he
Okay.
said, no, you're going to talk.
And then what happened?
I got out of the car. I
And what
started
did
to
you do
walk
after
back.
that?
I started to walk back into Amazon.
Okay. And what happened then?
He started screaming and yelling.
And do you recall what he was screaming and yelling?
I can't recall.
Okay. And how did you feel at that point in time, ma'am?
Scared.
Okay. And you said you started walking back to Amazon. What's the
Yes.
next thing that happened?
I did turn back around because he was screaming, and he just told me to get back in the car, that nobody needs to hear our business.
Okay, what happened after that?
My manager, the one that walked me to the car,
Yeah,
he was parked like over this way.
okay, I don't want you to say
Oh,
what,
sorry.
you can say what you saw him do,
Okay.
but you can't say anything that came out of his mouth. Does that
Okay.
make sense?
Yeah,
So continue, your manager was there with you?
he walked back, yes, and he's,
Okay, and what did you see next? What was the next thing that you saw happen?
basically, that to go back inside.
Okay, and you went back inside?
Yes.
And did there come a time when you made contact with police?
Yeah, the loss preventions called the police, so they were already on their way because they seen on the video camera.
And
Just for the purposes of the record, Judge, objection to speculation about.
I'll stipulate to striking that portion.
Thank you.
Ma'am, those are all the questions that I have for you right now.
Okay.
Thank you.
How are you?
Good, how are you?
Good. My name is Randy Robinson. I'm a defense attorney. I'm just going to ask you a few questions today.
Okay.
So you said you went to the police department to fill out PPO paperwork,
Yes.
and you filled out that paperwork at the police department.
No, to be honest, I can't remember. I
Okay.
think it was online, and then, because I went there first to ask them what I should do.
Okay. And so you got some forms offline requesting
Yes,
to get a PPO.
yes,
And did you print those forms off?
yes.
Okay. And once you printed those forms off requesting the PPO, is that what you mailed to Ronald?
I'm not too sure. I know once they were done and everything like that, and they got sent back, then I got them sent.
Okay, so you filled this paperwork out online. You printed them off, correct?
Right.
And then did you go to the police, or I'm sorry, let me back up. You had them notarized by somebody at a
Yes.
bank, correct? Okay, and then at that point, did you take the documents and put them in the mail to Ronald?
Yes.
Okay. And on the form that you filled out,
Officer Perkins has those. The only thing I've admitted is the order of the PPO.
okay. And so when you filled out that document, it had a bunch of check boxes about the conduct that you were complaining about, correct?
Yes.
Okay, and that conduct, included accusations of violence against you, but also against like animals and things like that, right?
I think so.
Okay, and you checked all of those boxes off, essentially, correct?
The ones that, had to do with me, yes.
Okay. Now, you put those documents in the regular mail?
I went to the post office and had it, sent to them.
Okay. Do you see a counselor or a therapist?
Therapist, yes.
You do?
Mhm.
Is it for anxiety?
I'm going to object to
for-
this line of questioning for relevant purposes, Your Honor. The mental health of the victim, unless it goes to her, unless it goes to alleged fabrication, I believe is completely irrelevant.
Judge, as Mr. King stated earlier, there is both a requirement that that the conduct in question would cause a reasonable person to fear harassment and so forth, and whether this particular individual did. And I think this line of questioning in terms of, actually, this objection from the witness, I think, could be prejudicial. So I don't know if we could have her just step out for a second. I can make a record or an offer of proof of where I'm going with this.
Maybe we could just approach for that.
Okay, would the court be okay with that?
Yeah, I'm gonna have you come around on this side though, because we are streaming
Okay.
and the microphones are. We're back on the record. The court's had a brief sidebar with the attorneys in this matter. Mr. King, you were making an objection.
Yes, Your Honor, I would object to this line of questioning. I understand that it's being offered regarding the elements of the offense, that to the element of whether or not a reasonable person would feel threatened, harmed, or intimidated in comparison to whether or not this witness subjectively felt that way. And it's being offered to go down the road towards those elements. And I would just say that I don't believe it bears relevance in that manner at all, because whether or not she has any sort of mental health diagnoses or whether or not she is seeking any therapy is irrelevant to whether or not she was reasonable in her reactions to these stimuli. Reasonable people can have unreasonable reactions, and unreasonable people can have reasonable reactions. And whether or not that person is in therapy doesn't have any bearing on that whatsoever. I would think that this is a way to backdoor character evidence, which is impermissible.
Judge, I stated the reasons for my request at sidebar. I thought that was the purpose of the sidebar, was not to have a full discussion in front of the witness. If the court wants me to make a record here, yes, I do think it's relevant to the elements of the offense. There are two standards, and I believe the condition of this particular witness is one of the elements that they have to speak to and that we're entitled to explore as a defense.
Your objection is going to be sustained, and Ms. Robinson, I'm just going to caution you just to be very, you've already indicated to the court that your questioning is going to be very short. I'm going to ask you to keep it short as relates to this particular narrow issue.
Okay, thank you. So, thank you for your patience. My question was, are you receiving any sort of counseling or therapy?
Yes.
And is that for anxiety?
Not only for anxiety, it's also for him.
Okay, but anxiety was a part of your therapy, correct? Anxiety is a diagnosis that you received from someone? Okay, and when did you start treatment for that, for anxiety and just stress issues?
Well, like I said, the only reason why I started therapy is when I got back together with him.
Okay, but it preceded March of 2000.
Yeah, I've been
21, correct? So you were in therapy before March of 2021?
Yes.
Okay, and do you take medication for that?
No.
Okay, I have no further questions.
Thank you.
Oh, ma'am, just check with my client.
Yes, ma'am.
No further questions, Judge.
Thank you. Any redirect, Mr. King?
No, Your Honor, I ask this witness be excused.
Ms. Cottrell, thank you so very much for coming in this afternoon. You may step down. Any other witnesses, Mr. King?
No further witnesses, the people rest.
Ms. Robinson?
Judge, I have no witnesses. I would ask the people, did you all release the officer already?
I'll check.
Perkins.
Okay, if he has not been released, I would just ask that, we receive the documents that we have him examined and have that admitted as a defense proposed exhibit. It's not a document that I received in discovery.
It's not a document that I have in my file. And
But
if he's not here, I'll give it to you by way of discovery shortly. I will agree with his petition.
Okay. Aside from that, Judge, I have no evidence.
Thank you. Mr. King.
Your Honor, I move for bind over in this case as charged. I can offer argument now, or I can reserve argument, whatever the court prefers.
It's how you prefer to put your case on.
So, Your Honor, as to count one, carrying a concealed weapon, the testimony of Officer Perkins was that he was called to the scene. He responded to this violation. He came there. He performed a search of the vehicle, and upon the search of the vehicle, a handgun was recovered. This was a weapon that was loaded and concealed within the passenger compartment of the vehicle. The existence of a legal right to carry the weapon is a defense. The lack of CPL is not an element of the crime. The weapon was recovered from the vehicle, for which the defendant was the sole occupant of the motor vehicle. The search has not been suppressed. I would say that the search was proper under several different grounds. First, that it may have been considered a consent search, as the defendant asked the officer to go in and see into the glove box. Second, that it could have been a search for officer safety, as they were called for a weapons offense. Third, as they had probable cause to search the vehicle based on other information retrieved at the scene. And also that it was inevitable discovery, as the vehicle would have been impounded and searched anyway. Whatever way you look at it, Your Honor, the search was proper. I asked that the court bind the defendant over on the carrying of a concealed weapon. As to the aggravated stalking charge, the elements are 2 or more unconsented, non-contiguous contacts with the complaining witness. We have those, Your Honor. We have the defendant coming to her work not once, but twice, 2 days in a row. First coming on the 23rd or 22nd, and then coming on the 23rd. These contacts have to be harassing in nature. Repetitive contact of this nature is by nature harassing, repeating the contact over and over again against her will. The contact has to be contact that would cause a reasonable person to feel threatened, intimidated, or harassed. And that is a reasonable person similarly situated. So not just anybody off of the street, but a person in the same situation. A person who had had a relationship with the defendant and had then sought out on their own a personal protection order based on what had occurred in that relationship, and desired no contact with this person and was continually contacted at work. So these contacts would make a reasonable person to feel harassed. He's coming to the place of employment where he does not have any other business being, and he's bothering this person. And that they actually did cause fear, the subjective and objective elements. So looking to the objective element, we have the statement from the complaining witness that she was upset, that she was fearful, that she was so fearful after the incident on the 22nd, she had a boss walk her to the car on the 23rd, and that she had fear caused by these incidents. We also have the fact that she was upset, visibly upset, when she made contact with the officers. What makes this aggravated stalking is that it was done in violation of a personal protection order of which the defendant had actual notice. Actual notice is separate from legal proper service. So we don't have to prove that the PPO was legally served upon him, only that he had actual notice of the PPO. And if you recall the testimony of the complaining witness, when she brought up the PPO to him, he told her that he believed it was fake. The fact that he believed it was fake and told that to the complaining witness before the police even got there goes to show that he had notice of its existence. He may have been in denial about its existence, but he had notice of its existence. In fact, the PPO documents, some of them, the petition for the PPO was recovered from his glove box. So he was on notice, Your Honor. He had actual notice of the PPO. So for those reasons, Your Honor, I would ask to find over on count 2, the aggravated stalking count.
Thank you, sir.
Judge, we would object to the bind over on both grounds. First, as to the CCW, I believe that the people have actual reasonable suspicion of probable cause before they seize an individual and then begin to search their property. And in this case, all we have is testimony from Officer Perkins that he got a report of a weapons violation. Well, that's some information to act upon, but that alone is not enough. When the officers arrive, they've got to do things to sort of independently, and I'm not sort of, they have to do things to independently establish whether or not they believe a weapons violation exists. In this case, what they did instead was immediately as they approached the car, they got their guns out, don't fucking move, don't fucking move. They ordered him out of the car, and then suddenly they're seizing his person. They find this weapon in the car, and then they also do some other things in terms of the statements that they elicit and so forth, all of which is troubling under the circumstances. Without that reasonable suspicion or that probable cause, I don't think they have a valid basis for going into that car. And again, them just walking up and deciding, oh, we heard a report of a weapons violation, and that be enough? I don't think the Fourth Amendment supports such an interpretation. And so we would object to the bind over as to the CCW offense. As to the aggravated stalking charge, unsurprisingly, what our argument is that there was no notice, actual or otherwise, to Mr. Molan that an order had been entered. Looking at the aggravated stalking statute, I'm going to read directly from the language of the statute, and this appears at Michigan Compiled Law 750.411, small letter I. At subsection 2 of that statute, it says, an individual who engages in stalking is guilty of aggravated stalking if the violation involves any of the following circumstances. And under subsection A, it says at least one of the actions constituting the offense is in violation of a restraining order, and the individual has received actual notice of that restraining order. Judge, whether you're gauging it by the testimony of the police officer or of the witness herself, it is clear that what Mr. Molan had received in the mail was a petition. Not an order from a court restraining him, but a petition, a request. And listen, he knows better now because we have this case and there's a whole charge and so forth, but at the time he had questions about it, and I think it's a fair question because I'm here making the same argument. A petition, an application, a request, which the witness says she printed offline, but had notarized, and that's what she put in the mail. That's what was sent to Mr. Molan. So he did not have actual notice of an actual court order being entered. There's no proof in this record of saying, and I think under the circumstances, Judge, yes, the court has an order that was put into the record, and so we're not denying that an order existed at some point. But whether or not he had notice of an actual order being entered as opposed to somebody making a petition, a request for an order is two different things, and I don't think the people can use one as substitute proof for the other. So for those reasons, Judge, I would ask this court not bind over on the aggravated stalking charge because the people have not given any information to show that he was on actual notice of an order. Order is what is required.
Mr. King.
Sure. As to the CCW charge, this was a Terry stop. They were called out for a weapons violation and they were investigating based on this tip that they had received there was a weapons violation. Furthermore, on the body worn camera that defense attorney played, you can hear the other officer, Officer Reyna, saying, "There's a gun," before the search. And it was the testimony of this officer, Perkins, that Reyna was the first one to notice the weapon. So based on the call, the statements of Officer Reyna, this defendant or this officer had more than reasonable suspicion to search this vehicle. Furthermore, inevitably he was placed under arrest for the stalking charge. The vehicle would have been towed and impounded and searched anyway. So there is an issue of inevitable discovery as that pertains to it. So I would say that the weapons charge stands either way you look at it, whether you believe that there was reasonable suspicion to search the vehicle subsequent to a Terry stop or an investigative stop, which is I believe, or whether you believe that the vehicle would have been searched inevitably and the weapon recovered as part of an inventory search subsequent to the arrest for the stop. Because even if it wasn't aggravated stalking, it was still stalking, it was still an arrestable offense. So one way or another, that vehicle was getting searched. So we have the inevitable discovery argument on our side with that as well. As it pertains to the actual notice of service of the PPO. Again, notice that the statute recited by Ms. Defense Counsel, which she did read accurately, states actual notice. It does not state proper legal service. Two separate things. If the legislature intended it to require that there was proper legal service of the PPO, they know how to do that because they require proper legal service of the PPO in order to bring a violation of the PPO hearing in family court. They do not require actual proper legal service, they require actual notice. The very fact that the defendant was in possession of the petition at the time that was sent to him by the complaining witness, and the defendant told the complaining witness that he thought the PPO was fake, goes to show you that he knew this PPO existed. He just didn't want to believe it. And I say this is a question of fact for a final effect at trial as to the notice of the PPO, but there's sufficient evidence to support a buy-over in this case.
Thank you, sir.
Judge, can I just make two quick other arguments, just for purpose of the record? I promise I'll be brief.
Ms. Robinson.
Okay, I don't think the inevitable discovery argument flows here. There's been no testimony in this record that this vehicle had anything to do with the accusations, and it wasn't a vehicle stop, this car was parked, and so I don't think it would have been inevitably discovered, so I don't think that logically follows. And I just also want to officially make the argument about the Miranda violation that occurred here. He clearly was in custody at the time that the police, let's even assume that they had reasonable suspicion when they saw the gun. They start asking questions after he's in custody about whether you have a CPL and so forth. Those things are clear questions that clearly call for an incriminating answer. And I would say every statement that he made after that, because he did not have Miranda warnings, must be suppressed. And so for those reasons, I would ask that the court not consider any of his statements about what was in the car and whether he had a CPL. Because at that point, that's the only way the police are making the case based on his statements. And he clearly was in custody and asked for incriminating information. Thank you.
Mr. King, is there anything else you want to say this afternoon?
Nothing further, Your Honor. Thank you.
Thank you. The court has had the opportunity to listen to the testimony of both Officer Perkins and to Ms. Cottrell in this matter, and the court finds that that the people have met their burden this afternoon, and Mr. Molman will be bound over as previously charged. Mr. Molman, your next appearance date will be an arraignment on the information at the Frank Murphy Hall of Justice on September 6, 2021 at 9 o'clock. That time and date is subject to change, so your attorney will be in contact with you if it is something different. Your previously entered bond with any conditions will continue. Anything further, Mr. King?
Nothing further from the people. Thank you, Your Honor.
Anything further, Ms. Robinson?
No, Judge.
Thank you very much. That concludes this matter. That concludes our afternoon docket. We are off the record. Thank you.